G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers. Welcome to the Australian Family and Fertility Law podcast. If you're watching this on YouTube, please subscribe. We love our subscribers. What I'm reading at the moment is the earthquake that came from the recent child safety inquiry by Paul Anastasio KC. This was commissioned by the Chris government in Queensland, given the number of children who are in resi care. It keeps blowing in and blowing out to massive numbers. So not only are these kids in resi care, but it's also, from a budget point of view, just unsustainable. I'm glad that the government is accepting most of Mr. Anastasio's recommendations, including that related to adoption. I've acted for clients who have sought to adopt children or obtain orders in the family court concerning those children where they've been the long-term carers. And I mean by that, they're the foster carers and they've been there for a long term. And the department, it must be said, are very difficult to deal with. They're fixed in their ways and seem to have forgotten their statutory requirements of best interests of that child. They're certainly not interested in adoption, even though adoption has been part of the legal landscape forever and is contained under the Child Protection Act. Mr. Anastasio's words are even more scathing than mine, and I think he hit the nail absolutely on the head. He said, and excuse me for reading this, adoption is a legislated option, effectively mothballed. Adoption is the only permanency option that removes a child entirely from the child safety system. It is the only permanency option that results in an order that legally endures after the child turns 18 years of age. It provides lifelong and intergenerational belonging that no guardianship order can replicate, and nor for that matter can any order under the Family Law Act replicate, because the Family Law Act does not create parents. Only an adoption order or a surrogacy parentage order can do that. Then he goes on to say, what is no surprise at all, but it's still shocking to read, in Queensland, no child has been adopted from state care since 2019. This is despite a decade of legislative mandates and repeated recommendations designed to boost adoption numbers from state care. The Carmody inquiry recommended in 2013, so 13 years ago, that adoption be routinely considered and pursued, particularly for children under 3. The government accepted that recommendation. The recommendation was closed out in 2019 with an assertion by the government that it had been implemented, at which point I'll just say it wasn't. There had been, at that point, 9 adoptions in the intervening 5 years, and the department's own principal legal officer accepted in evidence that the department had not in fact done what was asserted, and that the department could do better for all children. And the Deputy State Coroner, in her 2020 findings of the death of Mason Jet Lee, who was the child who was killed allegedly under the supervision of the Caboolture office of the department, and really wasn't. The department was woeful in its care, I use that with inverted commas, of that child, found that the recommendation had not been implemented in any real sense and made further recommendations. Legislative amendments followed. No adoptions have occurred since. The Director of Child Protection Litigation gave evidence that he had never been engaged to provide evidence on adoption or to represent the department in an adoption matter. And for the department to make an adoption application in respect of a child subject to a child protection order, the Chief Executive must be satisfied that adoption is an appropriate way of meeting the child's need for long-term stable care. That precondition is not being reached because adoption has not been entering the conversation at all. And the adoption practice manual sits outside the child safety practice manual, meaning that its contents are not routinely known by child safety officers in their day-to-day role. Adoption has been in effect institutionally invisible. Certainly, Mr. Anastasio's report deals with the legacy of forced adoption, and he goes on to say contemporary adoption in Queensland operates within a fundamentally different legal and ethical framework to when forced adoptions occurred. It is characterised by openness, judicial oversight, and a focus on the child's lifelong best interests. That distinction must be clearly understood by practitioners. Without it, historical harms will continue to foreclose consideration of adoption in circumstances where prolonged impermanence may itself cause lasting harm to children who cannot go home. Children endure so many placements. It's not unusual for 20, 30, 40 placements, and yet they're not being adopted. It's being ignored. And he then goes on to say, and I'll just come down to this, where a child under the guardianship of the state causes serious injury or death to a member of the public, the question of what the state as corporate parent knew, did, and failed to do is directly relevant. And he concludes, the state's responsibilities as corporate parent are discharged, or they are not, through every decision made about that child from that point forward, about where they live, who cares for them, whether a suitable guardian is sought, whether adoption is considered, whether disability is diagnosed, whether there's a plan when they leave detention, and whether the system reviews its own conduct when care fails with catastrophic consequences. The evidence on permanency is unambiguous. Over 80% of long-term guardianship orders are sought to the chief executive, the last resort in the statutory hierarchy, in a pattern so consistent and so persistent that it cannot be attributed to individual error or workforce pressure alone. It is a settled feature of practice. Absolutely nails it. Got it absolutely right. It is certainly a settled feature of practice. Adoption is simply ignored by departmental officers. Mr. Anastasio goes on to say, children who are in stable long-term family-based placements are not being considered for the guardianship that would give that care a permanent foundation. No, they're not. And the review mechanism, which exists precisely to prevent children from remaining on long-term guardianship custody order in favour of the chief executive indefinitely, is not being used. Fewer than 10% of children in the commission sample received that the review the law requires. Isn't that depressing? The other 90% deserved that review as well, but didn't get it. The legislation has not been sufficient to change practice. Structural compulsion is required, and the reforms recommended in this chapter are designed to provide it. The evidence on adoption is equally clear and more troubling for what it reveals about institutional culture. No child has been adopted from state care in Queensland since 2019. This is not a consequence of legal barriers or individual case complexity. It is the consequence of a department that has, over a decade, and in defiance of its own legislation, its own repeated commitments and multiple external recommendations, allowed adoption to become institutionally invisible. The fear of repeating historical wrongs is a legitimate concern. It is not a license to deny children who cannot go home the opportunity of lifelong legal belonging. The Commission recommends a fundamental reorientation of practice and the examination of simple adoption and integrated birth certificates as legal models better suited to contemporary understandings of identity, openness, and relational permanence. Hooray to Mr. Anastasio and his team. Absolutely got it right. These children deserve permanence. They deserve to have that stability and be able to grow and prosper in their childhood and their adulthood. And he then goes on to say, amongst other things, restore adoption to its lawful place. It is imperative that we keep faith with these children and deliver the change they need and deserve. So I wanted to share that with you. I thought that Mr. Anastasio has got that absolutely right, that this failure to allow children to be adopted and therefore to remain in the system and then ultimately end up maybe as youth offenders or in the resi care system or both has got to change. Thank you for watching, listening. I'm Stephen Page from Page Provan, Family and Fertility Lawyers. This is the Australian Family and Fertility Law Podcast. If you're on YouTube, please subscribe. We love our subscribers. Thank you.